And we are recording. Chair Schmidt, would you like to introduce the meeting?
Go ahead, Cheryl. I'm gonna ask if you could do that.
This is the Sunshine Ordinance Task Force Complaint Committee meeting of July 20, 2021. The time is 5:32. Shall I read the preamble, Chair Schmidt?
Yes, please.
Remote access to information and participation. In accordance with Governor Newsom's Executive Order N-3320, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London N. Breed's proclamation declaring a local emergency issued on February 25th, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process. Chair Schmidt, would you like to read meeting decorum?
Sure, I'll read that one. Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and or menacing behavior may be asked to leave.
Shall I call item number 1?
Yeah, number 1, please.
Item number 1, call to order, roll call, and agenda changes. I will call the roll. Member Forsley?
Here.
Member Forsley present. Member Wolf?
Here, present.
Member Wolf present. Chair Schmidt?
Present.
Chair Schmidt, we have a quorum. I do have an agenda change. I received word this afternoon about item number 6, file number 21026, complaint filed by Carl Kramer against Daniel Kaplan and the Human Services Agency for allegedly violating Administrative Code Section 6721 by failing to respond to a request for public records in a timely and or complete manner. Mr. Kramer informed me this afternoon that that case has been closed. He has received all his records.
All right. I have no other agenda changes. It looks like we still have number 4, number 5, and number 7 on for today. Am I right about that?
Yes, you're correct.
Okay, thank you.
Okay. Shall I read item number 2?
Yes, please.
Item number 2, approval of the June 15, 2021 Complaint Committee meeting minutes. I have a copy of the minutes right here. Does anybody have any suggested changes? Member Forsley, Chair Schmidt?
Nothing from me.
No, thank you.
All right. Let's take a. So, motion to approve.
Do we have public comment for meeting minutes first?
We will have public comment, but we need to see if we have a motion to approve first.
Thank you.
Who would like to move to approve the meeting minutes?
I won't make a motion because I wasn't there for that meeting, but I'll be happy to second it.
I'll move to approve.
I'll second it.
And that was a motion by Chair Schmidt.
No, you moved Chair Schmidt's. You moved Chair Schmidt. Member Wolf second.
Yes.
Yes. Okay.
And at this point, when you're ready, Cheryl, we can hear public comment on this item.
Yes, just a moment. Do we have public commenters?
Yes.
I'm sorry?
Yes.
Okay, that would be anonymous number 1. Do we have another public commenters?
Sure, this is anonymous number 3.
Okay. Do we have other public commenters? Okay, we have anonymous number 1 and anonymous number 3.
Yes, please.
I'm sorry, was that Mr. Warfield?
Yes.
Yes, yeah, it was, Cheryl. It sounds like that's our third.
Okay. Anonymous number 1, are you ready?
Yes. And I'm using a timer, which I will start when I begin speaking for my comment. So please do not interrupt or give a warning. Thank you.
All right, go ahead.
Hi, my name is Zach Carnazes. I've addressed you all before. Thank you for making this time for us to speak with you all. I've looked at the website under the Sunshine Audio-Archive-Committees webpage, which has the agendas, recordings, and MP3 audio for all meetings. There is no agenda. What agenda normally has the minutes. There's no agenda or link to anything I can find searching all over the website right now for the minutes that you're about to approve. I do not feel this is appropriate. I do not feel this is equal public access. It's very important that the public can review minutes from previous meetings that we attend to make sure that our words are accurately reflected in those minutes. I have severe disabilities, and it requires a lot of effort for me to come to these meetings and share with you the things that I share. And so it's very important to me that what I injured myself to do to share is accurately recorded, accurately reflected in those minutes. I ask that you please make sure that public records are posted at least a week prior to these meetings so that the public can access them. Otherwise, there's no point in having this public comment section. Why take public comment on the approval of the minutes? Why include the public? Why have a democratic process for that if the public cannot access those minutes, which seems to be the case now? Please post those minutes with the other records on the Audio Archive Committee's webpage, which is linked, which is the Sunshine Ordinance Task Force Committee archives page, which is where they should be. Additionally, please put in your agenda that there is public comment after this item, because it is not shown in the agenda that there is a portion for public comment on approval of minutes on item number 2 on this agenda. Thank you.
Thank you. Any commenters before we go to our next public comment? Okay. Next, I believe it was anonymous 3.
Please let me know when I may begin.
You ready, sir?
I am.
Go ahead.
Thank you. I'm going to try to consistently refer to myself as anonymous number 3 throughout today's meeting. This is a suggested correction to what is page 2 or P3 under the last time's general public comment for anonymous number 2, which was me at that time. It says I requested that news film clips of Mayor Breed showing sweeps of homeless people be covered by the SOTF. That first sentence should just say that I did.
Anonymous,
Sorry?
I hate to interrupt you, but I can't hear a word you're saying.
Can you hear me now?
That's better.
You sounded like you're underwater.
Yeah. Would you like
Okay,
to restart
can
the
you
clock?
hear me?
I'm sorry?
Can you hear me? Can you currently hear me?
Yes.
Oh, we can hear you clearly. Would you
Okay.
like to stop the clock so you can start over?
I don't need it. That's fine.
Go ahead.
Okay. It's just, it is a correction on page 2 or P3, which is item 3. It says anonymous number 2 requested that news film clips of Mayor Breed showing sweeps of homeless people be covered by the SOTF. No, I just merely discussed news clippings of Mayor Breed showing sweeps of homeless people. Be covered by the SOTF should be removed and requested should be discussed. Thank you.
Cheryl, I'd like to comment on the minutes.
Okay, I think we just,
I'm gonna, before we go to our next commenter, I do think that let's keep in mind that last edit by anonymous number 3 as to whether it was just a discussion of the subject. But at this point, unless there's comment by either of the members, we can go to our next public comment, which I believe was Mr. Warfield. And then there's another one after that who just indicated they want to make public comment.
okay, I just want to go back to anonymous number 3 because I didn't hear what his comment on the minutes was referring to, what number, what action.
Yeah, and let's go ahead, Cheryl. Let's allow him to speak to you to clarify where that is, because it sounds like it's a proper change.
Yeah. Anonymous number 3, could you direct me to where specifically you were referring to in the minutes?
Sure. Can you hear me?
Yes.
Okay. So it's page 2 of the minutes, halfway down the page, where it is my general public comment. I am referred to as anonymous number 2. And there are 2 sentences there. The second sentence is correct, and the first sentence is the one that I suggested a correction to.
All right. What was your suggested correction?
Sure. So all I suggested was it wasn't requested that SOTF cover it. I just discussed news clips, and the word film should be removed as well.
Yes. All right, got it. Thank you for pointing that out.
Thank you.
Thank you. Okay, good. When you're ready, Cheryl, we'll go to our next public commenter.
Okay. Is that Mr. Warfield?
Yes.
Mr. Warfield, are you ready?
I'm ready. Let me know when. Can you hear me okay right now?
Yeah. Yeah, I can hear you.
Okay. Let me
You
know
ready?
when to.
All right. Go ahead, sir.
Okay. This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com and also by mail. PO Box 170544, San Francisco, California 94117-0544. First of all, with respect to nomenclature and names and so on, I say these things because I consider them important, and I think that you should respect what your public commenters say and follow the law and summarize what they say, presumably even if you disagree or don't like it for whatever reason. You've consistently left out identifying information that I consider important and significant enough to say. And I've not gotten any explanation of why you don't do it, except in one of the subcommittee meetings. And I didn't think it was much of an explanation. I provide this information, as I've said many times, because I think it's important. LibraryUsers2004@yahoo.com, PO Box 170544, San Francisco, California 94117-0544. And yet, this Sunshine Task Force has managed to screw up or omit those simple things that I repeat again and again and again. So is it willful? Is it incompetent? What is it? What's going on? And why is there not a mention every time I mention it? I think it's fair to ask why not. Whatever your reasons are, I might disagree with them, but I think it would be reasonable to have a discussion as to why that's consistently been done. And you've done it again here. There's a first-time mention, which, thank you very much, finally is correct. But there's another mistake. In one of the references, it refers to me as the head of library users and leaves out association. So you've managed to screw it up again. Back to the comments. I wanted to second what Mr. Carnesi said.
30 seconds.
You should put off the approval until everybody can find what the minutes are. he's correct. This has been a problem for some time. It's screwed up. They're not where they're supposed to be. I don't think I complained about first-class mail at all. I think you should be prepared to deal with first-class mail in any of your procedures. And I don't believe I said there were a lot of complaints about that. And it's, as I said, it's Library Users Association is the full name.
What's up, sir?
May I
Thank you.
speak?
Thank you. And unless the members have anything before we go to the next commenter, when Cheryl's ready, we do have, you can go ahead with your public comment when she's ready.
Let me know, Cheryl.
Are you ready, sir?
Yes,
Go ahead.
I'm Patrick Manette Shaw. The first public speaker on the minutes, as well as Mr. Warfield, are completely wrong. The Sunshine Ordinance requires agendas to be posted 72 hours before a meeting. Today's meeting was posted on Friday. It was 72 hours beforehand. If you followed the link online, and I'm sorry, Mr. Warfield may not have access to a computer in his home, but I just clicked on the Board of Soups website, followed the link to today's meeting of the Task Force Complaint Committee, pulled up the agenda, and it's right there. On today's agenda, the attachments, including the draft minutes, are there. If you look at the agenda online, it says attachments. You can see it's a hyperlink, and they're right there. So I think both of them are wrong about not posting it in advance. I can see them. And I would like to just add, in a rejoinder to Mr. Warfield's comment of again and again and again, Mr. Warfield, we do not need to hear the library users' Yahoo account address and your post office box address on every comment you make on any agenda item. Please stop wasting our time. Thank you.
Okay, thank you. We may be done with public comment on this item. Anyone else? Otherwise, we'll have a vote. Whenever you're ready, Cheryl.
Okay.
If you could call the vote.
Yes. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wolf?
Aye.
Member Wolf, aye. Member Forsley?
Aye.
Member Forsley, aye. The motion moved by Chair Schmidt, second by Member Wolf, to approve the June 15, 2021 remote meeting minutes. Okay.
Yeah, when you're ready, Cheryl, we can call the next number.
Okay, just a second. Item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda.
Okay, does anyone want to speak for general public comment at this time?
Yes, please.
Yeah.
I hear 2 so far. Yep.
All of them.
Okay. Yeah, actually, yeah, give us a name of some kind. Sullivan and who else?
I think I was first, Warfield.
Okay, Warfield, Warfield, Sullivan,
Zach Carnazes.
Carnazes. Okay,
Anonymous number 3.
Anonymous 3. Okay, let's go ahead with, if there's anyone else, we'll fish you in also. But let's go ahead with the first one, Cheryl.
Okay, that was Mr. Warfield.
Yes.
Ready, Mr. Warfield?
Yeah, let me know when I should start.
Go ahead, sir.
Thank you. This is Peter Warfield, Executive Director of Library Users Association. You can be reached at libraryusers2004@yahoo.com and by P.O. Box at P.O. Box 17054, San Francisco, California.
Excuse me, Mr. Warfield. There seems to be noise in the background from where you are speaking. Can you mute that noise and start again?
Can I start over? Sure.
Yes.
Start over?
Let me restart
Okay.
the clock.
Is this better?
Yeah.
Can you hear me now?
Yes, it's much better. Let me restart the clock.
Okay. Tell me when.
Go ahead, sir.
Thank you. Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com and also by mail at P.O. Box 1705444, San Francisco, California, 94117-0544. And I'm sure there are many people who like and don't like things that other people say, and this is what I'm saying, and I have my reasons. Because I consider it important and because it's interesting to see how the task force seems to be doing so much out of the view of public in terms of decision making. I first of all want to appreciate that you have put on the later agenda near the end, although I wish it were early in the agenda, the discussion about complaint procedures. I'm disappointed that there isn't any further information about the action that's being contemplated. I think that when you have an action that's contemplated, it should be stated so that people can, if they're interested, understand what you're planning to do. I do think that it needs to be very seriously and very thoroughly discussed, and especially with some notice for folks. Certainly minimally at least as much as you would give for a bylaw change, which would be 10 days notice. But I think the public has an interest in this part as well as all parts of how the task force is working. And so in that regard, I'm hoping that you will expand your consideration of what's going on with the task force, how well it is working for the public, and so on. There are a lot of new members. I think I personally have a lot of hope that the new members will look with a fresh eye at what's happening overall. So, for example, I think that people's rights should be very clearly spelled out in plain English. James Chafee, who was the first vice president or the vice chair and the second chair, had a basic Bill of Rights that spelled out on a single page in detail what people's rights are. And I think that since the city departments have their lawyers pretty much on tap 24/7, I think it would be appropriate to have attorneys or at least some help for people who want to understand not only what their rights are, but what the consequences are, how to file complaints and what their rights are with complaints and so on. I do think that the task force needs to also look at the consequences and what its actions, including its internal actions, are doing to help or not help the public with respect to its overall effectiveness of the task force.
Thank you. Thank you. Okay. And before moving to the next one, I have to acknowledge I made a mistake earlier as I'm hearing Mr. Warfield speak. One of our members is not here today. We knew ahead of time that she would not be able to make it. That's Member Stein. And the discussion at number 8, it was our intention that she would be involved. And the subject matter is basically a discussion we do want to have about what we want to be doing when we hear a case in this committee, what we want to be doing, what we want to not be doing, but to be, to try to get clarification. And I know Member Forsley also is interested in that discussion, but we want to have it in public, and we want to have public comment afterward, but we want to do it. So I want to take that off calendar for today, unfortunately. I hope that there's nobody who, I mean, it wasn't specifically written out, and I think we may have it be more specific, although I don't know if we have any action intended. But I hope that we can put it on the next complaint committee agenda. Okay. Unless there's anything from the other members at this point, we can, oh, yes, Member Wolf.
Yeah, if there's going to be a change to the agenda, then I would suggest that it be done by action, right? Because it's on there, and it's on there for discussion and action. And if it wasn't formed, if it wasn't, fully formed out, or if the person who is, who put it on the agenda is not here and you want to postpone it, I mean, I would just say, let's postpone the item, okay? And do it now, or when public comment is over, we could bring a motion to the floor to do that.
Okay, thank you, Member Wolf. When we're done with public comment, I'm sorry, go ahead, Member Forsley.
Yeah, and I wanted to also add that I don't know if that agenda item, the first time we bring it up will be for discussion and action, specifically because we're starting the discussion. So I don't know if it makes sense to remove the word action from it, at least the first time we discuss it, because the way we had come about putting it on the agenda is that it's a much longer discussion that we'll be having over a specified period of time, not just over the last 20 minutes of one meeting.
Okay.
And if I could just quickly add, Member Wolf, if I could just add that there has to be some specificity of the topics that are going to be discussed. That's absolutely a requirement. To have just an open-ended kind of thing doesn't really help the public know exactly what we're going to be talking about. And if somebody, has to plan to be here, in the before the end of the workday, it would be best to flush it out and break it down into items. If the first discussion of this is to determine what will be discussed in future meetings, then that's appropriate. But if there is something that either of the members have that they want to bring forward, that they already know what they want, it should be put on the agenda. This is not about discussions happening behind closed doors or anything like that. There's nothing nefarious that's happening here. I think it's an unfair assertion to make. I think this is simply an, kind of an honest oversight among new members that are trying to get with the program here. So I'll stop there. Thank you.
Okay, thank you. All right, let's go ahead. Unless the members have anything else, I think I'm ready to go ahead with our general public comment, and then we should see if we have a motion to postpone that number. Okay, Cheryl, for general public comment, please.
May I
Okay,
please speak next?
yes.
Thank
Are you ready, sir?
Zach
I
Carnesi.
think we had Sullivan was second, I believe.
I can go later.
Okay.
Okay, thank
No
you.
big deal.
Mr. Carneses, are you ready?
Yes, I will be using a timer, which I will start when I begin my comment. So please, if you could not interrupt or give a warning of time, I would appreciate that.
Okay, but I do have to have my own clock running.
Of course.
Alrighty, ready?
Yes.
Go ahead.
Hi, this is Zach Carneses. I'm an advocate, District 9 voter, severely disabled. And I must say I have had tremendous difficulty in accessing these meetings and the complaint process with the Sunshine Ordinance. It seems that this department, and I hate to single out Cheryl is there because she seems like a nice person. She does not appear to be aware of the ADA and of what disability accommodations are, the importance of replying to them. This is a problem. I still have not received a response to my July 8th and July 13th emails. You know, I have to number things in my emails. I have a vision disability. I have severe lower extremity disabilities. I have to use special software whenever I use the computer. So I ask a reasonable accommodation that replies are numbered, and that just gets ignored every time. And I don't know why. I've asked for the ADA coordinator to help, and I don't know who that person is. No one's told me yet. These meetings are very hard to even access. I had to call 3 times with the 10-digit passcode before I could finally get it to submit properly. I've been told I was only given 24 hours for my last hearing with 3 items lumped into one hearing. I understand that the chair, Bruce Wolf, and others are working to improve that, and I really appreciate that. But we are treated very disrespectfully as members of the public. We're not paid here. We're just trying to improve public access for records and things. I hope you can treat us better and give us more time. Please don't limit and shorten the time frame for us to submit our records. Please don't give us only 24 hours or 72 hours before posting the agenda, because disability accommodations take longer than that. Thank you.
Okay, I think we may want to acknowledge that last public commenter, because there were some important aspects of what he said. I don't know if there are problems we need to address, but we certainly may want to consider it. Anything else from the members at this point? Otherwise, let's go ahead to the next public commenter.
Do we have another public commenter?
I know Sullivan was on the list. He may be next.
Mr. Sullivan?
Sure, I'm ready whenever you are.
Go ahead, sir.
At the last full soft meeting, there was a discussion around a custodian of records responsibility, section 6721C. The custodian of public records shall assist the requester in identifying the existence, form, and nature of any records or information maintained by, available to, or in the custody of the custodian. A narrow interpretation of that provision would be only to the records that are within the department. A broader interpretation includes available to, as they have access to the records. How task force members vote often falls on how narrowly or broadly you read provisions. The California Constitution, the courts, and the Sunshine Ordinance instruct you to interpret provisions broadly. Constitution Article 1, Section 3B2, a statute, court rule, or other authority shall be broadly construed if it furthers the people's rights of access, and narrowly construed if it limits the rights of access. Sierra Club versus Superior Court. Where terms are ambiguous, the constitutional canon requires an interpretation that maximizes the public's right of access unless the legislature has expressly provided to the contrary. In other words, all public records
are subject to disclosure unless legislature has expressly provided to the contrary. Williams versus Superior Court. Lundgren versus Superior Court. Civil statutes for the protection of the public are generally broadly construed in favor of protective purposes. This is all to say, if you are going to vote against a broad interpretation of a public access provision, then you should cite a specific provision of a statute that provides to the contrary, or is a specific exemption. Custodians of records of a department is a construct of the city departments and not of the Sunshine Ordinance. While the term department is defined as section 6720A, it is not used in conjunction with defining custodians of records or the availability to records, whether as part of the city government or other entity doing city work. Custodian of records is defined in 6721A. Every person having custody of any public record or public information as defined hereinafter referred to as the custodian of public records. This definition says every person, not even qualifying it to only city officials or a designated person. You just have to have custody of public records or information. If a city official responsible for a city program that interacts with people using the program or works with any person who has any public record or public information, then that public record or information is available to them. Thank you for your time.
Thank you. Public comment. I know I heard Anonymous 3 earlier. I believe that's the next person.
Please let me know, Ms. Leger, when I may begin.
Okay. You ready, sir?
Yes, I am.
Go ahead.
Thank you very much. This is Anonymous number 3. I wanted to wholeheartedly second the portion of Mr. Sullivan's discussion about broad interpretation of access, narrow interpretation of exemptions, and of course the requirement under the Sunshine Ordinance that the agency, quote, prove with specificity that the exemption applies. If they can't prove it, you should always rule in favor of the public. And the burden is on the agency and never on the public. But what I wanted to talk to you about here was, as usual, some victories and disasters in Sunshine. So this morning, I think as many of you know, London Breed deletes her text messages, so does the Chief of Staff, Sean Ellsburn. But I found out that Sean Ellsburn takes screenshots for some reason of London Breed's text messages and then distributes those screenshots of her messages to department heads. So I made a request for those screenshots, and Sean Ellsburn erroneously or accidentally replied all instead of to the lawyer, to me as well, saying, quote, "Nice try, Hank. I delete the screenshots too." Hank is Hank Heckel, the legal compliance officer. So it's great that there's so much bravado in their destruction of exactly what the mayor is up to. And last weekend, I actually found something similar done by District Attorney Chesapeake. In that case, his office tells one reporter, quote, "We are legally prohibited from discussing anything related to a juvenile case," end quote. And then sends one of the assistant district attorneys sends another journalist text messages containing the email address, phone numbers, names of witnesses in that same juvenile case. And this kind of controlling the narrative by choosing which reporters you provide information to is despicable. It's not allowed under the CPRA. You provide it to one, you provide it to all. They will not provide it to me, by the way, because of course they can't actually waive the privacy rights of these other people. They just did it anyway for positive media coverage. Thank you very much.
Okay, thank you. All right, anyone else for public comment, general public comment at this time? All right, there being none, Cheryl, when you're ready, we'll call the next number.
Just a moment. Item number 4, file number 21054, complaint filed by Patrick Manette Shaw against Grant Colfax, Veronica Vian, and the Department of Public Health for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and/or complete manner. This is the first time this case has been heard.
Okay, before we get into the cases, I just want to repeat what I've said before. This is a complaint committee, so what we're doing here today is limited. We're looking at the cases for certain purposes, and we, in many cases, will advance them onto the full task force. But let's do what we do. And let's start with, is Mr. Manette Shaw present? I think he is. Okay,
yes.
great. And is there anyone here for the respondents, Department of Public Health respondents?
Hi, this is Veronica Vian from the Department of Public Health.
Okay, great. So we'll hear first from the complainant, 3 minutes committee time.
Bruce, am I
When
correct?
ready, Cheryl.
Bruce, am I correct? Is it 5 or 3?
I thought it was 5.
Bruce, can you not hear me?
Yeah, I can hear you.
Okay.
How has this committee been operating?
My understanding was petitioner and respondent get 5 minutes to speak.
Well, Chair Schmidt, how
In
you
committee, I've been giving a 3 minute period.
It doesn't sound to me like it should be at the discretion of the chair.
One moment, please.
We're having a discussion about possible ways to proceed here. I know that the committee has had some interaction over what we want to do here, but since we have a sort of a limited mission, we've been working with 3 minute presentations. If there is a rule otherwise, I'd like to know what it is and where it is. But I believe this is something that's within the chair's discretion, although I'm certainly, we've talked about this between the regular members of the committee, and I believe that it was, we sort of had a process going. Did the members think anything otherwise?
Well, in history, it's been 5 minutes for jurisdictional. In the same way, opening testimony of a regular process is done when a hearing is actually a full hearing before the task force is. You're correct that there, I don't believe that there, unless the committee has its own rules, our complaint process doesn't necessarily specify. Hold on, I believe it. I don't think it mentions it for the committees. No. But it mentions it for the full task force. Generally, we've given the same amount of opening testimony time to both sides in order to provide them with, enough time to be able to explain their case.
Well, I'm not insistent on 3 minutes, but what I've been hoping to do is to figure out a way to efficiently get more cases through, at least while we have a backlog. And in my opinion, the backlog is a serious issue. So I've been asking to have a longer calendar. I mean, we can certainly talk about backlog at the regular task force in this committee, but it's at least my opinion, and maybe I'm the only one who thinks this, that the backlog has just grown. It's a problem, and I don't think that it's proper to have a backlog. As we sit here today, we only have 3 cases, so I'm open to having 5 minutes today. It doesn't matter to me. Any opinion on this, Member Forsley?
I mean, I think what we've talked about is attempting to truncate these meetings so they don't run as long as a regular task force meeting, especially since we're not deciding anything here. So I think 3 minutes is enough to elicit jurisdiction. I don't think we need much longer than that.
Okay.
Chair Schmidt, I would just caution that the task force has precedent that the public is used to, and not just the public, but the respondents too. And that maintaining some consistency and continuity over the course of 2 decades should be respected.
I forget, what did we do previously? Were we doing 5 minutes or were we doing 3 minutes at our previous committee meetings? Because they get to speak twice.
Yeah, I believe we've done 3 minutes.
Okay. Yeah, I just feel like for jurisdiction only, it's a situation where we already always go over the jurisdictional discussion, really for not really any reason, because we're just deciding that specific thing. Now, if we were making recommendations, and things like that, I guess it would make sense. But that was part of the discussion that we were going to be having. Like, what else are we going to do if these meetings are going to go as long as a regular task force meeting?
Members, I have to implore you that there are other committees that are hearing complaints too. If everybody's operating on a different process, that is not due process. And then what we'll end up having is petitioners requesting their cases to be heard by a different committee because they're operating differently. I'm sorry, that cannot happen. There has to be consistency between all the committees that are authorized.
Okay, I wasn't aware that other committee meetings weren't doing 3 or 5. I'm not really sure. So you're saying that other committees are doing 5 minutes?
I believe so.
Well, yeah, I mean, we would have to keep it consistent, but I would also ask other committees if they're just assigning or, jurisdiction, that they might want to consider reducing that time. But I mean, we're discussing this now, so we're taking up a bunch, some time here. But I think that if it sounds like other committees are still doing 5, we probably should continue doing it now. But I think it's something to look at, just so these meetings don't go as long as a regular committee meeting.
May I comment on this discussion?
I think at this point we want to stay just with members, because I'm thinking about doing is we're going to, because I believe that it would get us through today, is to allow 5 minutes on each side. But Member Forsley and Member Stein and I, we have had prior discussions about this. I agree with Member Wolf that precedent can be a very important thing. If the other committees are doing something that we're doing differently, that can be an important thing also. On the other hand, I believe that as a committee, we may have the discretion to set our own procedural rules. So I don't want to say that I am setting anything in stone. But I believe I have the authority, at least right now. And this is part of what we wanted to talk about as a committee. And that's what number 8 was going to be. But we need to set it into some more detail when we put it on our agenda so we can really talk about it. And so I'm going to, because we have people waiting, I'm just going to say we're going to give 5 minutes to petitioner and respondent here today. And then we're going to move on and see what we're going to do next time around. And we're going to talk about it later. Okay. So I think we're ready to hear from the petitioner. And Cheryl, give him 5 minutes, please.
Sir, are you ready?
I am.
Go ahead, sir.
This is Patrick Manette-Shaw. Let me just say you have it backwards. You have a subcommittee hearing. It's defined jurisdiction. The complainant should be able to have 5 minutes at the subcommittee level And if anything, cut it down. Once you find jurisdiction, cut it down at the full task force to 3 minutes. You guys have it totally backward. Let me proceed with my complaint. Today's complaint involves a records request to the Department of Public Health placed a year ago on July 6, 2020, for records on out-of-county discharges from SFGH and Laguna Honda Hospital for the period January 1 to June 30th, 2020. I'm going to refer to those out-of-county discharges abbreviated as OOC. On May 4th, 2021, I placed separate similar requests for OOC discharges from both hospitals for an additional period of July 1, 2020 to April 30th, 2021. DPH has provided the OOC data only from Laguna Honda for the first time period on July 28th, 2020, and then provided data only for Laguna Honda discharges for the second period in May of this year. On August 27th, 2020, a month after placing the initial records request, DPH's public records staff said it was still trying to get SFGH to acknowledge whether or not it was still using a different database named SF GetCare that probably contains OOC discharge data. Enclosure 4 attached to my initial complaint before you shows that on September 16th, 2020, DPH record staff claimed for the first time that DPH's new electronic health record system named EPIC does not track OOC discharge data, and that the data would need to be compiled manually from paper records. For almost 11 months since, SFGH appears to have made no effort to compile or provide the requested data manually, which could have been completed by now. The public records staff also claimed on September 16th, 2020, that DPH is not required to create documents not already in existence. That's ridiculous. DPH has historically provided me several times with such data for many years, providing OOC discharge data for both hospitals dating as far back as July 2006, 15 years ago. Furthermore, as I documented in my July 15th, 2021 supplemental information sent to you a few days ago, California Government Code Section 6253.9, parenthetically A2, which is part and parcel of CIPRA, requires local agencies to extract data from existing databases. This has nothing to do with creating new records. It only involves extracting data, which the DPH has done multiple times in the past. To repeat, on September 16th, 2020, DPH record staff first claimed its new electronic record system, EPIC, does not track OOC data. Can I continue?
30 seconds.
That's also ridiculous because, according to DPH's own press release, EPIC was rolled out a year earlier in August 2019. I repeat, EPIC was rolled out in 2019 before DPH claimed a year later that it doesn't track OOC data. I've got a little more to say in my rebuttal period, whether or not DPH rebuts my opening argument.
Thank you, sir. We'll see. Let's go ahead and hear from the respondents.
And no, it's not a what we'll see issue, Chair.
Thank you.
Ms. Vian, are you ready to start?
Yes.
You're going to have to speak up.
Hi,
It's
good
hard to
evening.
hear you.
Can you guys hear me better now?
Yes, that's much better. Thank you.
Hello?
Are you ready, ma'am?
Yes. Hi, everyone. Good evening. This is Veronica Vian from the Department of Public Health. We received Mr. Monette.
Oh, sorry. Excuse me. This is Member Forsley. Can the person please state what their title is at Department of Public Health?
I am the Public Information Officer for the Department of Public Health.
Thank
Thank
you.
you. Oh, you can go ahead, Ms. Vian.
Yes. We received Mr. Monette Shaw's public records request, as he stated on the correct dates. And once we were in receipt of it, we routed it accordingly to both our hospitals that the request is referring to, both Laguna Honda and also Zuckerberg San Francisco General. After connecting with both the analysts and data teams at each respective hospital, we determined that the Zuckerberg San Francisco General Hospital data, since transferring over to the Epic Care database, will no longer be hosting out-of-county discharge data. Therefore, it is not something or information that we are able to simply extract from the database. As for Laguna Honda, the database that's also being used is Epic. And when we were producing the records for Laguna Honda, which we have provided, those were actually manually crafted together and not extracted through a database. However, the dynamics of Laguna Honda Hospital and also Zuckerberg San Francisco General Hospital are very different. Laguna Honda Hospital is a skilled nursing facility and has much more limited out-of-county discharge data, which is why it was much more simple for our staff to manually extract that data and compile that all together. Whereas for Zuckerberg San Francisco General, given the hundreds of patients that are discharged in a yearly basis or even a biannually basis, it would be impossible for our staff to manually compile that data, also while managing our COVID-19 response during that time, in addition to making sure that all that data that will be manually compiled to be accurate and something that is reliable for the public to review as accurate data. So therefore, we did provide a response to Mr. Monette Shaw and let him know the responsive records and the responsive information according to Laguna Honda Hospital's out-of-county discharge data. However, for the Zuckerberg San Francisco General, we did not have any records to provide as it was a voluminous record to produce and also not an existing information that's already in our current database at use. Thank you.
All right, thank you. So we've heard from, are there any other speakers here to present on behalf of either the petitioner or respondent? None? Okay. Members, open to questioning.
What about my rebuttal period to what Vian just said?
We wouldn't have any kind of rebuttal at this moment, but we may have questions for you.
Mr. Wolf, educate this chair. That is the typical process that has been used for 20 years with SOTF.
Go ahead, Member Wolf,
I would just say we did change when the committees were charged with only providing for that the items, the records were public and that they were within our jurisdiction. We limited the amount of kind of the process so that everything else will be forwarded into the main hearing. We're not going to be making any determinations here. We're only collecting, making sure that the record is full, that we have all the information. We're not going to be arguing the merits of the case at this time. That'll come at the full task force hearing. Right now,
the information I want to provide is for the full record, and what Ms. Vienne just said is not the full record.
Well, you'll have an opportunity at the full task force to make those arguments.
All right, but I want you to know,
Mr. Minetcha, we gave you 5 minutes already, and that's your opportunity to present your case.
Okay, but she's lying.
You're asking for additional time. I will. Okay, unless I have a question for you, Mr. Minetcha. Okay.
Yes.
I want to defer to Member Wolf. Member Wolf, were you finished, or did you have something else?
No, I had a question for the respondent.
Okay.
So
I'm gonna, Mr. Minetcha, I do have a question for you, but I'm gonna defer to Member Wolf to ask a question of the respondent at this time.
Okay.
We'll get to you.
Okay, I'm sorry, the respondent, may I have your name again, please?
My name is Veronica Vienne.
Yeah, okay, Ms. Vienne. So I'm with regards to the transfer of information to Epic from General Hospital, when did that happen?
The transfer of databases happened in August 2019. That was when if you're asking about the data systems where we were using to track patient health information, that was the time of the transfer of databases, or when it started kind of going live, the new one going live.
And was that also the same period of time when the out-of-county discharge data was also basically terminated from the Epic system?
I don't think termination is the correct word. It's just the new database did not, as part of the new processes for the new database, tracking down out-of-county discharge data is not part of the processes.
So you're saying
that's a lie.
Mr. Minetcha, you'll have your chance. It's inappropriate to interrupt like that. I appreciate not doing that. So after August 19th, you're saying that General Hospital was not tracking out of county discharge data? Ms. Vienne?
Out of August 2019, the year 2019, not the date. Not that the hospital was not tracking out of county discharge. It's just the system itself did not track it.
The system wasn't tracking.
Database.
The database wasn't tracking it, but the hospital was tracking it.
I do not personally work close enough with the database to answer these questions directly, but this is what I was told in terms of when the database is not able to export accurate out-of-county discharge data.
All right, I'm very confused about how this database works. Is there a person that can be accessed that can give us more exacting information about how this works, so we can present. We have enough information to present to the task force.
I would have to identify the person who is the lead for the data information for Epic.
Well, it could be anyone.
That can be done.
It could be anyone who's a trainer. It could be somebody who's in charge of IT that knows how it works. Anybody who has more exacting information. Because right now I'm a little confused, and I'm a tech professional, so I'm a little confused as to what was being collected, what wasn't being collected, and if the information is in the database but could not be exported, that it would be a big question I would have.
I hear you. I can identify someone for the next meeting.
Okay.
To be present.
Thank you. I'll stop there for now.
All right. I'm going to ask, I'm going to start with Ms. Vian, and then I'm going to talk to Mr. Minette-Shaw. But, okay, you're the public information officer, is that correct? For public health? Okay. I think that if you are responding to requests like this, I'm wondering if you have spent any time reading a case called National Lawyers Guild versus City of Hayward, which is a California Supreme Court case that came out in 2020. Have you looked at that case at all?
No, sir.
Okay. It really is squarely the case that I think is important for this case. And so I just want to give that to you. It's a May 28th, 2020 case, NLG, National Lawyers Guild v. City of Hayward. All right. Now, a question from Mr. Minette-Shaw. Mr. Minette-Shaw, I'm wondering if you think that there's something that the respondent said in their presentation that you disagree with.
Yes, let me be as brief as I can. I reached out to Epic Corporation's Media Relations Department. I've exchanged several emails with them. And as I noted in my supplemental information on July 15th, Epic's standard configuration, according to its Media Relations Department, the enterprise package that is standard includes discharge destination and discharge dispositions, including the name of the city patients are discharged to in a Epic module named, quote, patient flow, end quote. It's thought Epic's clients, including SFDPH, can not choose at the time they convert and configure Epic whether they want to disable the patient flow module in any way or the discharge destination database fields. Here's the kicker that Ms. Vian and these unnamed experts in the IT department at SFGH do not understand. How many cities are there in San Francisco County? I think it's one. So if they were to write a simple database query that I could write, looking at which cities a patient is discharged to, if it is not San Francisco, ergo, it's an out-of-county discharge. This is complete crap that while the database may not have a canned report to built in its standard array of reports to find out-of-county discharges, they can easily, since I could do it easily, they could write a database query against the city a patient is discharged to, and reverse engineer. If it ain't discharged to San Francisco, ergo, it's an out-of-county discharge. This is not rocket science.
Thank you.
Does that?
I think so. Yeah.
And Ms. Vian's allegation that she doesn't know who the experts are in the IT department. I can tell you, the chief information officer at DPH is Eric Raffin. That's Raffin. I want to give a heads up to the task force. I'll be filing another complaint because when Vian told me that the database does not have out-of-county discharge information, that essentially is a denial of the records request. And I'm going to be filing a new complaint alleging that when I asked for the name of the person, theoretically, in the IT department who fed Ms. Vian this bullshit, that they had denied a feature that is available in the database. That's also a violation of CIPRA.
Thank you. I think that covers it. Appreciate that. All right. Any other questions, members? Otherwise, we can discuss now. Now, let me just say that I'm going to read two sentences from this National Lawyers Guild case because it's really interesting. It's about section 6253.9, and I think that what I'm seeing here, this is a case that would tell us, how the law works in this situation. But the Supreme Court said that the Public Records Act, quote, does not relieve agencies of the obligation to retrieve data to construct disclosable records. It then goes on to say that it instead protects them from any obligation to generate new substantive content. So that's where the Supreme Court draws the line in this kind of case. So I think that gives me some sense of what I think of the substance of this case. But we're just deciding, we're not deciding the case. We're just deciding whether to move this on or whether to do something else. Yes, Member Wolf.
Go ahead, Member Forsey. You were going to speak first. No.
Oh, I was going to make a motion, but if you have something else to add, you could do that first.
Yeah, I was going to just say in general that the information that's in the database, we've not heard from testimony that any of it is not public at this point. So I'm inclined to that the database is a public record. It can be disclosed to the public. I don't believe there was no response that I seen to Mr. Manette Shaw that there was any argument about that. So I'm going to assume that the record is public. It's definitely within our jurisdiction. And Member Forsley, if you'd like to make the motion, I'll be happy to second it.
Okay, yeah, I was just gonna make the motion that we do have jurisdiction, and yeah, is that it? That we
Okay.
have to do?
And the records are public?
Oh, and the record, yeah, and the records are public.
I would like to add, if you don't mind, that since we don't really have enough information about what was exportable or what was able to be extracted from the database in what year, that either a person who is knowledgeable technically about the database at the time that it was migrated from the old system to the new system, provide the task force with explicit description of what transpired at that time, what information is available, what information is not available, either in person or in writing, so that this file is complete for the task force. So the task force doesn't have to spend a half hour trying to figure out how the database works. If that's okay with you, Member Forsley.
Yeah, I mean, that's fine as long as it's able to be captured.
Member Wolf, are you saying that we would insist that certain information be obtained before this goes up for hearing to the task force itself?
Yeah.
That it would be, there would be a waiting period of some kind?
Well, I would say that in order to be able to ascertain what records the task force, if the task force chooses to take a positive finding of non-compliance, the task force should know what information was available at the time of the request was made, which was, I believe, July 6th, 2020, and what's transpired thereafter. And based upon the respondent's testimony here today, that it's that the representative is not clear as to what information was available at the time or not, what information was actually in the database, and if it was actually able to be exported technologically. I just was not able to get a clear idea of what exactly was available to the public at that time or not. So to me, that would not make the file ready for a hearing because we don't have enough information for the task force to go on. So that's why I'm requesting, as part of the motion, that that the respondent provide either the person, either in person or in writing, an explanation of how the system works and what information was migrated from the one system to the other at the time that the system changed. That Mr. Monette Shaw was unable to get these documents. That caused him not to be able to get them.
I think it's clear what you're saying. There's one thing that, and we've had this in other cases too. There's to me sort of a twilight zone where this committee or another committee might say, okay, well, we're going to approve this. It's got jurisdiction. But something's got to happen here. And so I think we want to make it clear if that thing happens, then what happens? If that thing doesn't happen, then what happens? And where does the case sit? Because I think our administrator, maybe it's all clear to her, but I want to make sure that it's clear to her where this case will sit, at least for the time being. Do we want to give a time limit also on how much time we have the respondent to find what you're talking about?
Sure. You want to put a time frame on it? Sure. I don't think
it needs to be in writing.
Mr. Minette Shaw, no. Please do not speak out of turn. I appreciate that. Thank you.
Needs to be in writing.
Mr. Minette Shaw, I will talk over you, okay, if you're going to continue to interrupt. Thank you. I don't think this should take more than 2 weeks. I don't believe that this file will be scheduled for task force hearing in less than 2 weeks. So I would suggest 2 weeks' time is plenty for there to be a response to this request. So
a response in writing.
Okay, thanks, Mr. Minette Shaw. We're just talking amongst ourselves. So basically, Member Wolf, you're saying we take Member Forsley's motion and we add on this, 2-week respond substantively about that subject matter, and yet we also send this thing
Mr.
on
Minette
to the
Shaw,
desk.
please do not interrupt. We don't interrupt you. Please don't interrupt us. Thank you.
Is that where we are?
Yes,
Okay.
That's fine. I would say in writing in 2 weeks to produce how the question of what information was transferred from the old database to the new database. If the information in question is in the new database and not extractable or exportable, why it was not? Why that isn't? Why is that the case? And any other information with regards to not being able to provide the records from the database for the period of time that the requester had made their request.
Okay, was that a motion, Member Wolf?
That is as an extension to Member Forsley's motion.
So it's an extension. This isn't an amendment.
We haven't. It's not an amendment. I am just adding on to the motion because there's no second. There's no second yet, so there's no amendment. There's no period of amendment. So I'm just adding on to Member Forsley's motion before there's a second to try and flush it out.
Okay. I want to make sure I understand what it is you want to say. So I am saying that you are amending Member Forsley's motion that the respondent provide either in person or in writing an explanation of how the information was transferred from the old database to the new database. And I was typing and I didn't get the rest of it, at the end of it.
I would have. Okay, so I'll say it again. Okay, you ready?
Yeah.
Okay. This is not an amendment. I am asking Member Forsley if she would be okay if I could expand on her motion to add this, that the respondent provide in writing from a knowledgeable person of this database and of the data in the database when the data was transferred or migrated from the old to the new, and if the information, the data that the requester is requested is contained in the new database, and whether the information is extractable or exportable from either of the databases for the period of time that the requester made the request. And that would be to provide that in writing in 2 weeks, within 2 weeks.
You got that, Cheryl?
Yeah.
Okay. And so I think next I should ask member Force.
I'll second. If member Forsley's okay with that addition, I will second it.
Yeah, let's see if she's.
Yes, that's fine.
Okay. Okay, so that's the substance of the original motion with augmentation, and member Wolf is seconding the motion. So we are then ready for public comment on this item.
Okay, just a moment. I'll be right with you.
It's not about migrated data, period.
Do we have public comment on the motion?
Anonymous number 3, please.
Okay. Do we have other public commenters?
Sounds like we have one. Let's go ahead with the first one.
All right.
I would like to be able to make public comment request when that one is finished.
Okay, we have two.
All right. Anonymous number 3, are you ready?
I am.
You have to speak up. Could somebody?
Can you hear me now? Can you hear me now? That's not me. That's somebody else. Yeah.
No, I'm not saying it is you, sir. I was about to ask it for somebody to mute if they're not speaking. Okay, Anonymous, I think we can go forward. Are you ready, sir?
I am.
Go ahead.
Thank you very much. This is Anonymous number 3. So I would agree with all the members of the committee. National Lawyers Guild, that court case is absolutely on point. Reading through the complaint, it does not appear that the requester has asked for any new substantive information to be created or recorded. They're just asking to get a portion of this database. And if you don't consider getting a portion of a database to be requesting a record, just remember, emails, it's not like they're separate files or something. The emails are stored in the database. And every time I ask for a set of emails, they actually have to construct a query. They have to run that query against their database of emails, and then they provide me that subset of emails. And there's no difference doing this here versus doing an email search. It might be harder, but that's not relevant. And when you discussed the metadata cases a long time ago, you did the same thing where you asked them to bring a witness about the IT information. They brought you the chief information security officer. And they discussed the difficulty of doing so. But what the task force stated at the time is the existence or difficulty of a tool for extracting information doesn't change whether it's disclosable or not. It doesn't change whether it's public or not either. And that's absolutely right. You know that the Sunshine Ordinance actually requires when they purchase new computer systems, they're supposed to make it easy to extract the disclosable information versus not. And if they haven't done that, that's their fault. You should find them in violation. And it has nothing to do with whether or not the information should be disclosed. And then they can go figure it out how to properly disclose it if they have not done so already. Thank you very much.
Thank you. And when Cheryl's ready, there's another public comment.
Was that Mr. Warfield who wanted to speak?
It may have been.
I did.
Yes. Yes.
Yes, Mr. Warfield.
Let me know when to start.
Go ahead, sir.
Can you hear me okay?
Yeah, we can.
Let me know when timing starts.
No, go ahead. Go ahead.
Thank you. This is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com. Also P.O. Box 170544, San Francisco, California 94117-0544. We're not a party to this complaint, and we're not particularly familiar, but we appreciate the discussion and the motion. I'd certainly agree with Anonymous. All of the mechanisms and all of the technicalities shouldn't be your concern particularly, although if you want to get information further about it, fine. I certainly agree with Dean Schmidt that things shouldn't be put in limbo because they haven't provided sufficient information for you to make a decision. They ought to be stepping lively to get the information that would support their potentially unlawful action. So by all means, give them a short leash and insist that they provide the information you need to follow what's going on. I wanted to particularly comment on something that came up during pre-hearing, if you like. You were going back and forth with respect to the procedure. And I certainly remember that every hearing had a similar layout in terms of timing. If you only have 3 minutes as though it's public comment, then precisely the issues that Mr. Manette-Shaw raises come up absolutely. How does the complainant respond to inaccuracies or whatever else is wrong or what they think is wrong with what the respondent has said? There isn't really any way other than to have the kind of hearing structure that you have in the full task force. What I think is really unconscionable, and it's not the fault of anybody immediately present in the room, and that is that the complaint procedure as it stands does not specify what the procedure is for the subcommittee. It talks about the full task force, but it doesn't give any specificity with respect to
30 seconds.
What is the structure, what is the timing of a subcommittee hearing. And the idea that willy-nilly a chair could change the rules and completely surprise complainants, I think, is really wrong, and is one of the things that's wrong with the complaint procedure, which definitely needs a lot of work.
Okay, thank you. Public comment, anyone else? Okay, I think we're ready for a vote.
Member Forsley?
Aye.
Member Forsley, aye. Member Wolf?
Aye.
Member Wolf, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. Moved by Member Forsley, seconded by Member Wolf, that respondent provide either in writing or provide either in person or in writing from a knowledgeable person of this database and of the data when the data was transferred from the old to the new, and if the information that the requester requested is contained in the new database, and whether the information is extractable from either database for a period of time that the requester made the request, and that they provide that information in writing within 2 weeks. Is that correct, Member Wolf? I typed it as you spoke it.
Yes, it is. That is correct. Thank you.
All right, great. Perfect. So, Chair Schmidt, are we ready for the next matter?
Next matter, please. Number 5.
Item number 5, file number 20051, complaint filed by Anonymous against Trent Rohrer and the Human Services Agency for allegedly violating Administrative Code, Section 67.29-5, by failing to keep or cause to be kept a daily calendar wherein wherein is recorded the time and place of each meeting or event attended. This is a new matter.
Okay, 5 minutes. Let me just make sure, is there someone here from the Human Services Agency?
Hi, yes.
Okay, could you state your name, please? Hello? Your name again?
Hi, this is Patrice Brown. I work as the assistant to the custodian of records for HSA.
Okay, great, thank you. So we'll start with 5 minutes from Anonymous. Anonymous, we're not sure which number yet, but we'll figure that out. Cheryl, when you're ready.
This is Anonymous number 3, who is the Anonymous here.
Okay, I was just going to ask that. Thank you very much. Sir, are you ready?
I am.
Go ahead.
All right, so if you could go to page 15 of the PDF, which is footer page P51. That's the update as of now. It is the final general audit of the entire city complaint from, I guess, started in 2019, the last one. And in this case, it's about the Prop G calendars of the department head for HSA, Mr. Rohrer. He was asked for the quote, the specific calendar required to be kept by SF Administrative Code 67.29-5, also known as Prop G calendar, for your department head, et cetera, with each and every meeting item for November 10th to November 17th, 2019 inclusive. And they provided, which you can see on page, oh, it's out of order. Let's see which page number we got. The Prop G calendar they provided is on page 44, P44 or page 8 of the PDF. And I've given you some asterisks of the non-compliant entries here. For some reason, they have this as a Prop G calendar, and they have some other non-Prop G calendar information as well. I'm unclear as to why they don't include that other information, which they clearly have, and they responded to a different request with it in their Prop G calendar. But if they did, they would be slightly more compliant if they were including that other information that they clearly do have. But these things are not enough. Deputy directors meeting, that's not a general statement of issues discussed. Mayor Breed's monthly department head meeting, not a general statement of issues discussed. Weekly with Susie, not a general statement of issues discussed. Dan weekly, meet with Mayor Breed. Executive committee meeting, etc. These are not general statements of issues discussed. They also don't have a listing of every attendee who's not within his department. At least in some cases, this task force found that City Hall was an insufficient location. You also have to give a City Hall location room number. So yeah, I think this is broadly non-compliant. I've emailed them about improving things or agreeing. They never responded. So here we are today. And that's all. Thank you very much.
Okay, thank you. And now we can hear from the Human Services Agency representative.
Hi.
When Cheryl says, I'm sorry, we need an indication that Cheryl's she's ready to record.
Gotcha. Okay.
I'll be with you in a second. And your name's, ma'am?
Patrice Brown.
Are you ready, ma'am?
Yes, I am.
Go ahead.
Okay, well, as the Anonymous stated, he submitted a request, immediate disclosure request regarding specific calendar items for Trent. Our office provided the responsive records as they were entered onto Trent's calendar. I did notice in some instances there were locations, and in other locations or for other entries, they were not specific locations or attendees. They just weren't on there. We didn't think those notes were required, and no additions or nothing else was added to it. So we just provided the documents as they were as is. That's all I can provide.
That's
Any of
fine.
my
That's
colleagues-
fine.
Yeah.
Thank you. Thank you. Okay. Let's go ahead and see what the members think on this. Looks like it's one of our Prop G calendar cases that we've certainly seen before. I don't necessarily see how we handle it any differently myself. Yes, Member Wolf.
Yeah, so I don't see that if there's any more information to ask for in order to make the file ready for a hearing. I would move to find that the records are public, that it's within our jurisdiction, and to forward it to the task force for hearing.
I will second that. This is Member Forsley.
Okay, we have a motion, and so we can have public comment on that motion whenever you're ready, Cheryl.
Do we have public commenters?
Sure.
Here, Mr. Warfield. Do I hear anybody else? Anybody else for public comment?
Looks like we have one.
Right. Mr. Warfield, are you ready?
Yes, I am, if you can hear me okay.
Yes, we can hear you. You may begin.
Start.
Go ahead.
This is Peter Warfield, Executive Director, Library Users Association, Library Users, 2004 at yahoo.com. Also P.O. Box 170544, San Francisco, California, 94117-0544. This looks like one of those cases where you wouldn't even have to have a hearing. The documentation seems completely clear and damning. So certainly we support your motion. We're not a party to this and familiar with the details, but we've certainly heard enough and seen enough. One of the things I would say is that there have been sort of asides from the chair and so on about how this is another, and indeed it is another. And I think that's another issue that the task force has to take up, and that is when there are repeated violations of a similar nature, and coming from, in this case, one of many city departments, presumably that with the mayor at the head, then I think the task force has to consider what it can do to, instead of dealing with each, shall we say, insect, to recognize that there's an infestation and that something bigger has to be done other than just finding this one wrong and this one wrong and this one wrong and this one in violation and so on. And I think that the task force has to deal with that as well in terms of how it handles complaints and how it resolves complaints. Thank you very much.
All right. Thank you. Is there anyone else for public comment on this item? Looks like no more. Okay, so we're ready for a vote when you're ready, Cheryl.
Member Wolf?
Aye.
Member Wolf, aye. Member Forsley?
Aye.
Member Forsley, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. Moved by Member Wolf, second by Member Forsley, to find that the records are public, there is jurisdiction, and to forward the matter to the task force for hearing.
Very good, and looks like we'll move on to, I believe 6 is not happening. Looks like we're at number 7, Cheryl.
Item number 7, file number 21039, complaint filed by Carl Kramer against the Department of Public Health for allegedly violating Administrative Code, Section 6721, by failing to respond to a request for public records in a timely and/or complete manner. This is a new hearing.
Right.
I just have a disclosure, Mr. Chair.
Oh, sure. Yeah.
That I know Mr. Kramer, but my connection with him would not bias my decision making here today.
Okay. Thank you, Member Wolf. Is Mr. Kramer present?
I'm present.
Okay, great. And anyone here for the Department of Public Health?
Yes, this is Veronica Vian for the Department of Public Health.
Perfect. Okay, so we'll hear first from Mr. Kramer. 5 minutes when Cheryl's ready.
All right. Just let me know when, Cheryl.
I will, just a moment. You ready, sir?
Okay, I can make this very brief. So our researchers sent a request for information on December 17th, 2020, and on page 189 is the information requested, and never received a response and filed a complaint on April 9th, 2021.
All right, thank you. Respondent, you have up to 5 minutes. When Cheryl's ready, sorry.
Sorry about that.
That's okay, just take me a second. And this is Ms. Vian?
Correct, this is Veronica Vian.
Veronica Vian, okay. Just a moment, I'll have your time set. Go ahead, ma'am.
Great, thank you, Cheryl. Hi again, everybody. My name is Veronica Vian, Public Information Officer for the San Francisco Department of Public Health. We received a request through our online platform from Kylie Deha on December 17th, and we provided a response to the requester on December 23rd, informing them that the records that they were requesting were not available at that time. And we closed out the request due to the current time. At the current time, we did not have any responsive records to provide. Thank you.
Thank you. Members. Questions for the witnesses? Go ahead. Member Wolf, please.
Ms. Vian, your testimony, you just said you didn't have any records to provide at the time. What does that mean?
When the request was made, this specific request looked like it was asking for information that was recently affected. Give me 1 second. When I say at that time, when we received the public records request, I consulted with our internal team to determine whether or not there were responsive records, and there were none produced at that time. In terms of there were no records to produce in response at that time.
So there are no records. Okay, I'm not sure I understand that statement. I'm just reading the original request, and to quote, "We are requesting your department's calculations of the effects of the wage increase and the process for adjusting budgets of nonprofits with which you contract," unquote.
Correct. So the request was asking for essentially how funds will be allocated once the Department of Health receives these funds. At that time, the department did not have a plan on how those funds will be allocated. Therefore, there were no responsive records.
Is this a regular process from year to year?
I am not sure what the specific funding is. I believe it was a specific wage compensation amendment that happened during that time of the year. So I can't say that it happens every year.
Right. So is there some sort of standard that exists? I mean, if it happens every year, then, are you saying that the calculations at the time of the request didn't exist yet? Or are you saying that they don't exist at all? If they existed in a previous year and, there's some standard formula, that's kind of what it sounds like the requester was asking for. Do you not have that information?
When I look to our subject matter experts for responsive documents at that time, which was months ago, they did not have any records to be responsive, specifically to the change that had happened.
Okay, I'm not going to claim that as a response. Was Mr. Kaplan engaged on this? Because the request was made to that person directly as the custodian.
Was that question directed towards me?
Yeah, that's to you, Ms. Vian.
I am looking at the request right now, and I have not seen any correspondence between the requester. The requester has not made any messages towards us.
Well, I'm looking on page with the printed page number 166. Do you see that page?
I see 184.
166.
If we're looking at item number 7, correct?
Oh, I'm sorry. I might be looking at the wrong file. Hold on. I may have to retract what I was just my thought here. Okay. Please, somebody else, if you have any questions, go ahead. I need to.
You're on mute.
Mute, Mr. Chair.
Sorry. Thank you. I was on mute. Okay. Any questions from any of the members? I don't know if I have any questions. I think I can see what's happening here. I don't see that anyone else has any further questions. Member Wolf, do you feel like you finished your line of questions?
Yes, I do. I'll retract what I said before. I actually had I had the previous one.
The other Kramer case.
Yeah.
Okay.
And,
Got it.
That one was pulled. So.
Sure.
I have no questions.
Understandable. All right. Yeah. Any thoughts on this? I mean, I just it does look like they got some communication among people at the DPH, and they thought that at that time maybe there were no existing documents that responded to it. So I mean, it's plausible that that's what happened here. I don't know how. I don't know what else there is to this case, really. I know that they probably generated this afterward. I bet if he made the same request now, he may get a different answer. There may be documents. I don't know. I'll leave it at that.
I have a question for the petitioner, though.
Please do.
Mr. Kramer, in the record here, I'm looking for the original request. Was that submitted to our office?
Yes, this is a problem with the departments that are using the portal Next Request, is that it's difficult to make a copy of the initial request to get to Cheryl. And I think what our researcher was doing was like taking screenshots of what was on the Next Request portal. And then also, what I know what the researcher was doing was sending replies back to, on that portal, doing further requests for that information, asking, well, do you have it ready now? Do you have it ready now?
Okay. I see that there is some reference to attachments with regards to images and links to the Next Request system. Let me just ask our administrator, Ms. Leger, it doesn't look like those attachments made it into the record here. Is that correct?
Member Wolf, could you give us a page number that you're looking at?
Sure. Let me get to the first time I see it. That would be on page, let's see, 91, starting on 193. It's page 11 of the PDF.
Okay, thank you. 193, below our attachments.
Right. Ms. Ha is, or I would say person Ha, had responded or had tried to send the actual request and other evidence called image002.png, and then underneath that, the request number.
Public Health Request 20-503.
5003. If that's the one that pertains to this case.
It's the public, it was received on December 17, 2020.
Yeah, but it's not included in the record here. I don't see it, unless I'm looking at something that is it, and I don't recognize it.
Bruce, if I could speak, I think that page 189 may be the screenshot, and that might have been that attachment.
That could be. Thank you for that clarification.
Oh, is that it? I'm waiting. Okay, on 189. Okay, got it.
Okay, so Mr. Kramer, 189 is then the attachment that's referenced on 193. Is that correct? At the base of 193.
I believe so. I think that's correct.
Okay.
All right, just want to make sure that we have all the information needed sending this up the chain. Okay.
I'm going to ask a question of Mr. Kramer. I'm trying to figure out why you believe that there would be documents and that the response that said that they didn't have any responsive documents is an incorrect response.
Well, they should have at that point. I mean, the money was released December 8th, and they should have had something prepared. But I know that, unfortunately, this is the problem of using next request, and I've kind of, advising our researchers not to rely on using next request, because then when they, I know that she did further requests, but as a reply to the response from next request, and then was later asking, well, do you have this prepared now? And they at some point they had to have known what money is going to which organizations, and had something prepared as a document.
Well, it sounds to me like what you're sort of saying is that maybe they hadn't gone through the process, so they got your request when they did, but there were no documents at that time. Possibly that's true, and then yet later on, if they got another request, yeah, they did go through the process. Is there a possibility that that's what happened here?
Well, if you're saying at the time that the request was made on December 17th,
yes,
that they hadn't yet developed their plan on how they were going to allocate that funding, yes, that's possible. But
okay.
I know that the researcher was making further requests.
Okay, so subsequent requests to this one, correct?
That's right. Yeah.
Okay, because I have to sort of be a little bit, I have to stay with the request as is. And we're looking at the request. We can't make the decision here today, but the full task force can. But it looks like, we had a request that was made a specific date, and that's the request we have to make a decision on eventually.
Mm-hmm. Yes, I understand. I think that has to do with the shortcoming of using that portal.
Yes. So if you want to push this forward, and you're certainly entitled to, based on that request, then the question becomes: did they or did they not, give you any documents on that date that would have been responsive based on the wording of your request? But that's your choice whether you want to push that forward. But we have to stay right today. I think it's subject to what motion we have here in the group. But now I will defer to Member Wolf.
Mr. Kramer, I have a question. First of all, I agree with you about the next request, this screenshot here, because the rest of the request is actually truncated with a read more link. So I can't even see the rest of the request. So that's, I see how fortunate it is that way. I do have a question with regards to, so you testified that, did you receive, I just want to make sure the chronology here. Did you receive the adjustment On December 8th. Is that what you said?
Is that a question, Mr. Kramer?
Yeah, to Mr.
Okay,
Kramer.
Mr. Kramer.
No, on December 8th was the effective date of when the wage increase was to take place. And so our information request was December 17th, which is 9 days after the effective date of the wage increase.
Okay, so but you had not received the information with regards to the wage increase. Did it already happen on December 8th, or was it you just got notice that it was going to be happening on December 8th?
December 8th was the effective date of the wage increase, so that city-funded nonprofit workers were receiving that increased wage after December 8th.
Okay, so is it your contention that the department should have already had the calculations prior to December 8th?
Yes, they should have.
Okay. Okay. Thank you. I'd like to note for the record, Mr. Chair, that particular point be put into the brief to brief the task force when this hearing comes before them.
You talk about the December 8th.
Yeah, that the calculation was made, had to have been made prior to December 8th. December 8th was the notice of the adjustment, and the request for the calculation is on December 17th. So I'm just noting the chronology here.
You said December 17th? Remember, Wolf?
The request was made on December 17th to HSA. Employees would have been receiving the adjustment on December 8th as per notice, which means that the calculation would have had to have been used prior to the 8th, and the request was for those records. So I just want noted for the record as chronology that we all agree as to where that is. And let me ask Ms. Vian, are you in agreement that is the chronology also?
The chronology, according to Mr. Kramer's timeline, I will need to have a recap on the timeline before I can either say I disagree or agree.
Okay. Well, when you provide your response, or you can provide additional response in writing, you can include it there before the hearing comes. So the task force will have it. Is that okay with you?
I can definitely provide a timeline from the public health perspective before the full task force meeting, correct?
Great, thank you very much. Okay, that's all the questions I have.
So I just want to be clear, Member Wolf. To your belief is the calculation had to have been made prior to December 8, and the notice of adjustment and the request for the calculation was on December 17.
No. According to the testimony from the respondent, the notice of the adjustment was on December 8th, and that thereafter, that day or soon thereafter, the employees were receiving those adjusted wages. Okay, which means that the calculations that were being requested had to have taken place before December 8th. The request for the records was on December 17th. And
Okay.
that the response from the respondent was on December 23rd, with stating that they have no responsive records. So I'm just recapping the chronology for everyone, so the task force is clear as to as to what is happening here in this process.
All right, I'll put that in the minutes.
Okay.
Anyone
That's all.
want to make a motion on this?
I'll move to find that the records are public and that they're within our jurisdiction, and recommend that this be forward for a hearing to the Sunshine Task Force, and that the notation of that I made around the chronology be referred to the task force also. I mean, I guess that we could do that verbally. That's all right. And just make that part of that verbal report. Yeah, just forget about that last part. Just that the records are public and it's within jurisdiction, and the recommendation is to forward to the full task force.
And who would like to second that motion?
Second. Chair Schmidt. So we're ready for public comment on that, on this item.
Do we have public commenters?
Anonymous number 3 is one.
Okay. Do we have other public commenters? Okay, I guess.
Go ahead, Cheryl. Yeah.
Anonymous number 3?
Yes, can you hear me?
Yes, I can. Thank you. Are you ready?
I am.
Go ahead, sir.
Thank you very much. I think the most important part of this is taking all inferences in favor of the public. And his original request on December 17th, or I guess his employee's request, states, we are requesting your department's calculations of so-and-so and the process for adjusting the budgets. And so even if it's possible that the calculations weren't computed, the formulas may or should have already existed on December 17th. And it's possible that communications or documents or memoranda about the quote-unquote process for adjusting the budgets also existed. And it's unclear whether, I get that they're saying they hadn't yet evaluated how the funds would be allocated, but it's possible that the process, maybe the description of how it had happened before or something else, if you broadly interpret his request, would be responsive and should have did exist on December 17th and should be provided. And I think there is an issue with next request here. This complaint was filed on April 17th, I think. And so all the back and forth, if there was any on next request, isn't visible here. So maybe they did clarify or expand the request. And I think you should take into account everything that happened before April 17th. It's quite possible there's some other information here. I don't know. Maybe they didn't. Maybe this is the extent of the request. But even though, unfortunately, I experienced this, the requester can't go look at that log. It's impossible for us to do so on next request. The respondent agency can produce an audit log for this request 205003, and it should have all the back and forth if there was any more than this. And it would be nice for you to ask them to enter that into the record. Thank you.
Thank you. Anyone else for public comment on this item? Sounds like we've concluded public comment on it, so we can have a vote.
Member Wolf?
Aye.
Member Wolf, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Forsley?
Aye.
Member Forsley, aye. Moved by Member Wolf, seconded by Chair Schmidt, that the records are public to forward the matter to the task force and that there is jurisdiction.
Okay, I think for number 8, discussion regarding complaint procedures, I think we're going to
continue.
Move to, I'm sorry, go ahead, Member Wolf.
Move to continue at the call of the chair.
Okay, second that. And let's see. We
and did we want to take this up at the next complaint committee meeting?
Yes, with something more, possibly something more specific as to what the substance of the discussion is going to be. This has been developing among the members of the committee, and yet we need to flesh it out a little bit to figure out what we're going to talk about.
Okay. Do we want public comment?
Is this a public comment item?
Well, the motion is to continue, so yes.
Okay.
Public comment on all action items.
Okay, thank you, Member Wolf, Chair Wolf. Yes, let's go ahead. Public comment on this, number 8.
Yes, please.
Okay, we do have public comment. Let's go ahead when you're ready, Cheryl.
Do we have other public commenters?
Yes, anonymous, please.
Mr. Warfield,
Yes.
are you ready?
Let me know when to start.
Go ahead, sir.
This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com and also by mail at P.O. Box 170544, San Francisco, California, 94117-0544. We'd appreciate your including this whenever we've said it, and perhaps you can get it correct. First of all, we certainly have no objection to continuing the matter, hopefully to a soon to happen meeting, and with clarity, as we asked at the beginning of the meeting during public comment, and I'm glad that Chair Wolf agrees with this, there has to be some clarity with respect to what it is you want to do. Do you want to chop off the hand of the right hand of the person who doesn't follow all the procedures properly? Do you want to, what is it exactly that you want to do, or even in general, what you want to accomplish or what you want to do? It would be probably helpful if whoever wants to put this on the agenda, if they might come up with, for example, suggested changes or suggested wording. I would certainly ask for you to perhaps send out a special notice well in advance, like you would for bylaws changes, so that people who may have things to say from their own experience or otherwise have a chance to know what's coming and what it is you're going to discuss. Your complaint procedure is one of the core things that bears on how you do your work and how well it goes for the public. It is crucial. I'd also like to suggest that you solicit members of the public that have come before you or filed complaints before you, either in a survey kind of a way or just in an invitation way, so that they can know that this is an opportunity for them to express what they've experienced, what they would like to suggest, and so on. I also think that you really need to put this in context. There are so many things that go on behind the scenes, things that are sent back and forth between complainants and the administration, between the administration and the respondents, all kinds of things, the way that you set up the agenda packets, all kinds of things, how fast the whole process goes. That goes to more than just the specifics of a complaint procedure, but overall how you do your work. And I think that needs to be reviewed.
Your time is up, sir.
Thank you. Thank you. Okay, next, when you're ready, Cheryl, next public commenter.
Anonymous number 3, are you ready?
I am.
Can you speak up?
Am I still underwater? Hello?
We don't know yet. We can't tell yet. Go ahead and try.
Okay, can you hear me? Hello?
Yes.
Yes, we can hear you now.
Okay.
Yes. You ready, sir?
I am.
Go ahead.
Thank you very much. This is anonymous number 3. Obviously, I would support the motion to continue since it's not obvious what it would be, and I do agree with I think everyone who has spoken, including the members who spoke, that additional detail would be very helpful. I think it is a great idea to give a bit more notice for that. The procedural justice creates substantive justice, and that's true, just as true at the task force as anywhere else. And in some ways, I think this was discussed by Mr. Karnazes and Mr. Warfield and Mr. Chafee at previous either letters or full task force meetings, that kind of how you set the difficulty bar, the bar you have to get to, really affects who can come before you and whether they can get justice before the task force. And I think some of your members discussed that during the Chafee matter, and I think it requires some more thought, especially that matter, about what is the bar and what is the purpose of, for example, increasing investment required by a complainant to prove that the city is violating the law, for example. And should there be such an investment, or should you, as Mr. Chafee said, kind of run with it and be the representatives of the public to determine where the city is complying or not complying with the Sunshine Ordinance, CPRA, or Brown Act? Thank you very much.
All right, thank you. Any other public comment? There being none. I guess we should have a vote on that.
Member Wolf?
Aye.
Member Wolf, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Forsley?
Aye.
Member Forsley, aye. Moved by Member Wolf, seconded by Chair Schmidt to continue the matter to the call of the chair to the August Complaint Committee meeting. Is that correct?
Yes.
Okay. Next item, Chair Schmidt.
Yes, please.
Item number 9, announcements, comments, questions, and future agenda items by members of the Complaint Committee.
Okay, I'm going to start by saying that number 8 just was a bit of a mix-up. Part of what happened with that is that all of us on the committee were wanting to have a discussion, including Member Stein, and then something came up where now she couldn't be here. So that kind of stymies what our intent was. We intended to have a discussion. We did not have a proposal of any kind. And it's limited to how we run the hearing itself. And so not about
just a moment, Chair Schmidt. Whoever, could you mute yourself, whoever has the cat in the background?
Yeah, that was not me. it was limited to what we do here in this 2, 3, 4 hour hearing, and in the interest of figuring out what is it we want to do, what can we do, and how do we get things done efficiently. That's what the intention is, and I hope that that's what we want to talk about at the next meeting, and I hope all the members can be there for that. There's been also a request by Member Stein to put something on that agenda, and I guess we'll need to do that too, to talk about the packets and the content and the pages of the information packets. She wants to do that too. I don't know if we'll do both of them next month, but I just want to say those requests are out there. But I think that's the only announcement I have in terms of complaint committee matters. Anything from any of the other members? Okay. Let's see, I guess we should allow public comment on this, even though we don't have an action. So any comment from the public? Cheryl, or I'll ask first. Any commenters? Okay, yes. No public comment. Oh, we do. Yes. Okay. Yes. Thank you. Yeah, we have at least one.
Hello?
Yes.
Mr. Warfield, do you want to make a public comment?
Yes, please.
You can proceed.
Go ahead, sir.
Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com and by mail at P.O. Box 170544, San Francisco, California 94117-0544. First of all, thank you for the announcement, if you like, or the future agenda item mentioned by Chair Dean Schmidt. This task force, I think, is in desperate need of some very serious thought about effectiveness for the public and effectiveness in doing what it is intended to do. I have said numerous times that I think there's been a neglect of the sections 67.30 and following, which has to do with your call to look at the larger picture, to advise the supervisors and others to essentially do whatever you think it takes to advance open government in this city. I think, for example, that quite right for Member Stein to be concerned with packets. As far as I'm concerned, they're a catastrophic mess. They have everything, including the kitchen sink in them. They're very hard to follow. In the past, you wouldn't even have the complainant have the first word, which is what you would presume would make sense because the complainant is what set off the whole thing in the first place. Now there is still a whole mess of things that are very hard to follow. For example, in the last discussion, I couldn't find the request. I had trouble finding the complaint. There wasn't a kind of index that I thought would be useful for any kind of back and forth discussion. And oddly, I have found some of the attachments are searchable, but some are not. Somebody says go to P something, and it says not found when I search for it. What's going on? And how might that be made better? But I think there are other things as well. I think, for example, how you handle withdrawals. I think it should be much more formal. The law and the process up to the point of withdrawal have all been helpful, presumably, to the person making the withdrawal, or maybe not. But I think that you should at least try, on an optional basis for the complainant, to find out what happened
Your time is up, sir.
Just as an example, thank you.
All right, thank you. Any other public comment at this time? No further. We can move on to the next item. Cheryl?
Item number 10, adjournment. I have 8:01.
Okay. Move to adjourn.
Second. Okay, please call the time for adjournment after the motion and the second and the vote is made. That's when it's official.
Okay.
And please call for a vote, Mr. Chair.
Okay. Can we have a vote on adjournment?
Yes. I call a question.
Moved by member
Oh, go ahead, Cheryl. Sorry.
Schmidt,
Sure, I'll move.
you did, and
Aye.
member Wolf second, yeah.
Yes.
So we're taking a vote. So Chair Schmidt,
Aye.
Chair Schmidt, aye. Member Wolf,
Aye.
Wolf, aye. Member Forsley,
Aye.
Yeah.
motion to adjourn passes.
In the future, adjournment is a simple procedural. You don't need to call the roll. You can say, all those in favor say aye,
Okay.
Meeting's over.
All right, I'm going to stop the recording.
Okay, thank you.
So,
All right, thank you.
All
Very
right.
good.
Thank you.